Thinking Like a Lawyer, An Introduction to Legal Reasoning by Kenneth J. Vandevelde. Welcome to this comprehensive journey through Thinking Like a Lawyer by Kenneth J. Vandevelde, a modern classic that demystifies the intellectual process behind legal reasoning. Whether you're a law student, a professional in the legal field, or simply curious about how lawyers think and argue, this book serves as a powerful roadmap into the mind of a legal thinker. This summary-style guide will walk you through each section of the book in detail. We'll dive into how lawyers approach problems, analyze laws, reason through complex legal disputes, and ultimately craft arguments that persuade judges and juries alike. Part 1. Basic Legal Reasoning. Chapter 1. The Nature of Legal Reasoning. Legal reasoning is distinct from other forms of thinking. It isn't pure logic or philosophy, but a hybrid. It balances logic, precedent, statutory interpretation, and real-world application. Vandevelde opens by explaining that the foundation of legal reasoning lies in analogical thinking and rule-based analysis. Key points. Law is fundamentally a system of rules, but these rules often conflict or are vague. Lawyers don't just apply rules, they interpret and adapt rules to specific facts. Legal reasoning is argumentative in nature. It aims to justify outcomes using accepted legal authorities. Chapter 2. Sources of Law. Lawyers pull from multiple sources when making arguments. Statutes, legislation, regulations from administrative agencies. Case law, judicial decisions often used as precedent. Constitutional provisions. Understanding how to identify controlling authority is crucial. Lawyers assess whether a law is binding or persuasive, jurisdiction and relevance, the hierarchy of authority, e.g., constitutional greater than statutes greater than case law. Chapter 3. Precedent and stare decisis. This chapter introduces precedent, one of the most fundamental tools in legal reasoning. Courts look to prior decisions to maintain consistency and fairness. Core ideas. Stare decisis means to stand by things decided. Precedents can be binding from higher courts or persuasive from peer or lower courts. Lawyers often argue by drawing analogies between current and prior cases. Crucial skill, distinguishing cases, arguing that a precedent should not apply because the facts differ. Chapter 4. Statutory interpretation. When the language of a statute is unclear, lawyers use various tools of interpretation, such as textualism, what do the words say? Intentionalism, what did the legislature intend? Purposivism, what is the broader goal or policy of the law? Other techniques include examining legislative history, canons of construction, the statute as a whole. Chapter 5. Synthesizing the law. Lawyers must often synthesize multiple precedents and statutes to form a coherent legal rule or test. For example, in tort law, multiple cases might help define the elements of negligence. Lawyers create doctrinal frameworks by identifying common themes across cases, reconciling conflicts between authorities, constructing tests, e.g., the reasonable person standard. Synthesis allows lawyers to predict outcomes and shape their strategies accordingly. Chapter 6. Applying the law to facts. Legal reasoning culminates in applying abstract rules to real-life situations. This involves identifying material facts, matching those facts to elements of legal rules, anticipating counterarguments, addressing ambiguities. Lawyers also assess risk. How strong is the argument, and what are the odds of success? Part 2. Legal Reasoning in Practice. Chapter 7. Reasoning in Contracts. Contract law relies heavily on intent and the language of agreements. Lawyers must interpret contractual language, literal meaning versus party intent, analyze offer, acceptance, consideration, evaluate breach, damages and defenses, duress, mistake, unconscionability. Key skills: distinguishing between express and implied terms, assessing performance standards, weighing public policy when enforcing agreements, Vandevelde emphasizes that predictability is essential in contract law. Businesses must rely on stable legal interpretations. Chapter 8. Reasoning in Tort. Tort law addresses civil wrongs like negligence, assault, or defamation. Core structure of a negligence claim: 1. Duty. 2. Breach. 3. Causation. 4. Damages. Lawyers evaluate whether the defendant owed a duty of care, if that duty was breached, the foreseeability and directness of harm. The role of policy is significant here. Courts balance compensation for victims with the costs of liability. This chapter emphasizes moral and economic reasoning. Chapter 9. Reasoning in Constitutional Law. Constitutional law involves interpreting foundational legal texts. Key modes of reasoning: textual analysis, literal interpretation, originalism, meaning at the time it was adopted, living constitution, adapting to modern needs, structural reasoning based on relationships between constitutional principles, doctrinal approach, applying precedents and tests. Issues often include balancing individual rights versus government power, federalism, state versus federal authority, separation of powers. This area demands multi-dimensional analysis, often integrating philosophy, history, and public values. Chapter 10. Reasoning in Civil Procedure. Civil procedure governs how lawsuits are conducted, not the substance of law itself. Lawyers use procedural reasoning to choose the correct jurisdiction and venue, navigate rules of pleading, discovery, motions, manage evidence, and trial strategy. A common theme is strategic decision-making. Lawyers weigh when and how to act for maximum advantage. Procedure deeply affects outcomes. Many cases are won or lost on procedural grounds alone. Part 3. Broader Perspectives on Legal Reasoning. Chapter 11. A Historical Perspective. Legal reasoning has evolved over centuries. Vandevelde traces major traditions: formalism, 19th century. Law as logical rules applied mechanically. Realism, early 20th century. Judges' values and social context matter. Post-realist theories, critical legal studies, feminist theory, law, and economics. Understanding this history helps lawyers appreciate why legal methods are what they are today, and how they might evolve further. Chapter 12. Contemporary Theories. This chapter examines modern critiques and expansions of legal reasoning. Critical Legal Studies, CLS, argues law is not neutral. It's shaped by politics and power. Feminist legal theory challenges male-centered assumptions in law, seeks inclusion and equity in interpretation and application, law and economics, applies cost-benefit and efficiency analysis to legal rules. Narrative theory, law as a storytelling practice, how we frame facts affects outcomes. These perspectives encourage critical reflection, urging lawyers to be aware of biases and structures influencing the law. Chapter 13. Conclusion. Becoming a Legal Thinker. Vandevelde closes by reminding readers that legal reasoning is a discipline of precision, creativity, and judgment. The best legal thinkers read carefully and think critically. Analyze multiple angles. Accept ambiguity but strive for clarity. Understand that law exists in a social context. To think like a lawyer is not merely to follow rules. It is to challenge, adapt, and apply them with reason, empathy, and strategy. Appendix. A survival guide for law students. A bonus feature of this book is its practical guide for students, including case briefing, break down cases into facts, issue, rule, analysis, conclusion, FIRAC, class. Preparation: be ready for Socratic dialogue. Focus on understanding patterns, not memorizing rules. Outlining: create organized summaries of legal doctrines by topic. Integrate cases and statutory rules. Exam strategies: use IRAC, issue, rule, application, conclusion. Practice under timed conditions. Focus on argumentation, not just right answers. Final thoughts. Legal reasoning is not reserved for lawyers alone. It is a rigorous, structured way of thinking that can benefit anyone who seeks to understand the law, argue effectively, or simply navigate the legal world more confidently. Kenneth Vandevelde's Thinking Like a Lawyer offers more than an academic primer. It provides a lifelong mental toolkit for critical thinking, argumentation, and legal problem solving. Thanks for watching English Book Tales. If you enjoyed this journey through words and wisdom, don't forget to like, share, and subscribe for more inspiring stories, powerful book summaries, and a touch of romance. Let books spark your mind and stories touch your heart. Hit the bell icon so you never miss a tale. Until next time, keep dreaming, keep reading.